Hello, I'm Leonard Lang with CalRegSolutions.com. Today we're going to talk about rulemaking and a meeting that's coming up this week in Sacramento. CalRecycle will be holding an informal meeting on rulemaking for what's known as prepayment controls. Now, why is this meeting coming about? Well, last year the state auditor published a report over a year ago. And in that report they said, although state law authorizes CalRecycle to reduce or deny payments based on violations found during its review, our legal counsel has advised us that some of CalRecycle's policies and procedures regarding prepayment holds would likely be determined to be unenforceable underground regulations because they were not properly adopted as regulations in accordance with the Administrative Procedures Act, which requires CalRecycle and other state departments to allow public comment on proposed regulations. It goes on to say, nevertheless, despite a myriad of activities that CalRecycle engages in to prevent and detect fraud, evidence we receive suggests that CalRecycle's anti-fraud activities result in relatively limited financial recoveries for the beverage program in the form of restitution, that means the recovery of amounts paid improperly from the beverage program, and penalty assessments against those who violate the beverage program's rules. Simply stated, CalRecycle wastes a lot of money getting very little done. Now, we can speak to all of this. Now, the reason we're having this first meeting is because this occurred. Now, I'd been talking to the department about this for a long time before this report, but the department was not responsive. If the department was responsive, we wouldn't be here making these videos today, but we are. We're trying to alert the public and those affected by these rules, by these regulations, what's happening to them and why it's happening to them. Now, the first process is the informal process. They're having the meetings in Sacramento. Very few people show up for those meetings, but I will be there. And hopefully others will be there. But the department knows that the majority of the recycling in this state is done in Southern California. And if they want input and want to permit input and transparency, they will again hold a meeting like this or more than one in Southern California. That's what industry needs. That people in this business can't afford to go flying off to Sacramento every time Sacramento wants to have a meeting. The state needs to come to the industry and needs to make it convenient and easy for them to participate. Now, one of the things that this talks about is allowing the public to comment. That was the term from the attorneys at the auditor. That's a very important process. So one of the things that we're concerned about in this whole rulemaking process is, will CalRecycle permit the adoption of permanent regulations, or will they take advantage of a catch? That catch is that in the original legislation back in 1986, the department was permitted to adopt emergency regulations anytime they want. Emergency regulations do not allow the industry to comment. And CalRecycle has a permanent exemption from having to adopt permanent regulations. They can do anything they want with emergency regulations, and they never have to change those emergency regulations into permanent regulations to allow the industry to comment. We want to make you aware of this. We want you to understand the process. We're going to see how this meeting comes out on Tuesday. There'll be follow-up videos after that. But if the industry is going to be able to survive, it must be involved, and it must be involved with these regulations. What we've seen in the past is that, and especially in my conversations with staff, is that staff always says, we're following instructions. Now, on November 18th, the Association of California Recycling Industries held a luncheon, and at that luncheon, Tabitha Chavez, a supervisor under the certification branch, spoke on behalf of the department. Also, the U.S. Department of Labor spoke. After the representative from the department spoke, and much of her presentation had spoken to underground regulation, which the department has been imposing, I asked her a significant question. I asked her, as people involved with enforcement, had they been advised of the director's determination of underground regulation, which was a published letter to the Department of Administrative Law, April 29th, and posted on the notice registry around the 24th of May in 2013. For 2 years I had been fighting for that, and it was an amazing happenstance that the perfect attorney, former director of the Office of Administrative Law, petitioned, and the department was forced to acquiesce and admit that they had imposed underground regulation. They continue to still use that document. They can still use components of that document as underground regulation. Now they use it in training classes. They're using it in their tests. And it just goes on and on and on. It's an underground regulation that refuses to die. So the department has been caught. The department must correct. The department has taken well over a year and told the OAL, or no, told the auditor that they would adopt these regulations a lot sooner. Kind of points back to the original audit of 2010 by the state auditor, where everywhere they pointed to was ineffective management. These meetings with CalRecycle pertaining to prepayment controls are going to be one of the most important sets of meetings in this program. For years they've not done this, now they're being forced to do it. If you think you've been having trouble with underground regulations, if you're concerned about where this program is going, or if you're concerned that other departments have been imposing underground regulations, contact us at info@calregsolutions.com. We can help. We'll show you how to understand the process, how to survive in this process, and how to prevent the government from doing things they shouldn't be doing. Leonard Lang, CalRecycle Solutions.